Good morning, friends. Sat Sri Akal, Adab, Namaskar. This is my 199th video, continuing from the 197 video of Jabalpur. This is the case of Purnia, a tiller or an agriculturist holding some piece of land which is approximately in MOUZA BAROCHI, which he claims in 1924. The case is of plot number 73. The plaintiff pleads that the land was formerly MALGUZARI land and that for the last 60 years it was recorded as MILKIYAT SARKAR, and that after the settlements of 1885-86 it was shown ROYTWARI land and ordinary rights were conferred. So MALGUZARI lands were shifted to ROYTWARI, and the DC report says that the ROYTWARI lands were either owned by the Cantonment Authority, because it was the government which was originally the owner of the property, not the British Army. So this property has been in the possession of this owner, son of GANESH KURMI. His name is PAMAI. So this land he claims to be falling in MOUZA BAROCHI, that is 1 acre of land. So the Cantonment Authority says is a trespasser, land was never acquired by Cantonment Authority, and even if so, they were never compensated for it. Now the defendant, as it is, pleads in his case that the plaintiff was a ROYTWARI tenant or an occupancy tenant. He denies that. Even denies the MALGUZARI rights prior to 60 years. No such rights exist. So the Defendant Union of India is countering everything in this case. It was basically the Secretary of State India then in 1924. But the land, he says, is governed by various cantonment acts and rules. He talks of Gazette notification of Jabalpur of 1880. He doesn't talk of 1861. He doesn't talk of 1870. He straight talks of 1880 and then 1888. And the third notification of Jabalpur in 1910, where he clearly says these are now the cantonment and this property falls within the boundary pillars. So issues were framed. Was Puran a ROYTWARI tenant with full proprietary rights of land in suit? Is plaintiff now the sole ROYTWARI tenant and is entitled to sue? Does the notification dated 1880 put an end to the Puran Singh's rights of claiming as a tenant? Is plaintiff entitled to declaration sought by him and any other relief by the plaintiff? So what are the court findings? It goes and states no, Mr. Puran is not a ROYTWARI tenant, neither does he hold proprietary rights. The further point says that neither he is a ROYTWARI tenant and he is not entitled to sue. Now coming to that, whether the notification ends the right of Puran after 1880, the court says yes, it does. Now further it goes on to say whether the plaintiff could have filed a suit for declaration. He says no, he couldn't have. So 1924, the judge has totally gone against the pleadings and everything. Now court states that ejectment alone cannot be done arbitrarily. That's all. So now if this owner wants to prove this benefit of not being ejected arbitrarily, he needs to come up and prove that either he is a ROYTWARI land or under the Tenancy Act of the Central Province he has been given this suit property in 1830 under this. So who's a ROYTWARI tenant? Who has or holds directly from government land and his revenues assessed separately. So ROYTWARI, the first in principle is that you are a government land and further government has given you this land, and now under these settlement reports of 30 years, 20 years of possession, you will be termed as owner. Now what does the Tenancy Act of the Central Province regulate? The relation between a landlord and tenant. And before any person can claim the benefit of the provisions of the Act, such relation must be proved. Now how do I prove? How do I prove? I am in possession for the last 1830 to 1924, more than 95 years. So no record has been shown as Puran has been assessed under the revenue. The settlement reports very clearly termed Gair Mora's Kashtkar land of the whole of the village, which is being termed. Nothing was proved about. Even the settlements of 1885, 1886, some Jaggu Musalman was recorded as an ordinary tenant. This was wrong as there was no landlord. Now the court is even going on saying that even after the settlement, if Mr. Jaggu, a Musalman, was recorded as a tenant, is wrong. So correct the revenue records, that means. Why is the judge writing all this? Guys, we were slaves there in 1924. We have to understand, anything what my lord would say would be a kind of a hard line. So everything is going against. So when something is recorded, it becomes a matter of evidence. But here, by giving a statement that the entry in the revenue records or the settlement reports are wrong. And the law is very clear, the records cannot be, land revenue or the revenue records cannot be altered. Now, why are they being altered? Very clear, he is saying that Section 3 of the Cantonment Act 1924, where it is written, the central government may by notification in the official gazette declare any places along with boundaries and parts and forces is quartered or being in the vicinity of any such place or places is or are required for the services, any such force to be a cantonment for the purpose of this act and of all other enactments from the time being in force. Now the court only reads this part of the, doesn't read the second part, which now says and may be a like notification declare that any cantonment shall cease to be a cantonment. So rule 3 very clearly says you can either take in land or you can give land back to the DC or the civil municipality. So the central government may like by a notification define the limits of the cantonment. But nowhere he is saying in these rule 2, 1, subpara 3, 4 that the province of the enactment relating to local self-government under this act shall affect any only to such extent or subjects of the modification. So people, rule 3 needs to be understood and read with rule 4. Now here only one rule is being read but not the other. So no record whether compensation is given or not. Here there is a very important document called Exhibit PW2, which is talking of history of the Cant Jabalpur when was being made. And this was under DW1 that lands were acquired after 1905. So 1826 no land was acquired. 1861 when the boundary pillars were made, no land was acquired. 1880 when cantonment first boundary pillars were given, no land was acquired. 88 no land. 1905 land was acquired, and then the 1910 notification came. So here he is mentioning a case of Madras court, which is again on presumption. That presumption, if not rebutted, is presumed to be correct. So the judge here says that I cannot believe that compensation would not have been paid when the cantonment limits were being made under the 1910 or earlier orders. So a presumption is being drawn that compensation would have been paid. Where is it? We are not getting into that. So the judge talks of section 61 of the Cantonment Code, which is speaking of leases. Now how does the code imply? When the 1889 Cantonment Code was there, 1912 was there, then the Act of 1910 came, where in section 24 and 25 it very clearly depicted the same rule 3. It says any area under rule 25 can be annexed within the cantonment, Any area can be left back. No evidence is being led by the plaintiff, and the best part is the Secretary of State is not doing anything, but it is the intern of the judge who is doing everything. So even if there is no compensation paid, which is coming on record, there is a presumption. Now the court goes on to the second part, is admission. Now what is the admission the court is taking? We people are scared of admission deed that land belongs to government under GGO 170. No, here the government is saying this admission is that you have admitted that you are a lessee and he is a lessor, cantonment committee. And this relation and arrangement is being happening on a year basis. Prior to Puram Singh, it were the earlier ones who were doing it. So these are kind of statements which the Honorable Court is giving during the 1924 order. And it goes down to state in 1924 that within the cantonment boundary pillars, no act is applicable called Tenancy Act or the Land Revenue Act. Why? Are we out of bound? Or are we special laws only which will govern us? So then how come TPA Act or Registration Act were being applicable to us? That's the problem. So these kind of sweeping statements and observations were given by my lord in 1924. So he again comes back to the same pleading which now in 2015 also the Honorable Courts interpret, that under the Crown Grant Act of 1895, Section 3, TPA Act is not applied within the cantonments and grants are non-transferable. Guys, if the advocate or the pleader could have adjudicated on this point, he would have simply said, Ki Janab, in 1924 Act also read Rule 286, registration which says under TPA Act. So there are so many discriminations, briefings, pleadings. Now this bungalow owner even talks of discrimination. There was no constitution in 1924. He says there are n number of people in the cantonment agriculture lands who have been given discriminatorily leases again and again. No auctions have taken place. The judge has gone down to say that was a matter of grace which the cantonment executive officer had been rendering, but it does not confer hereditary rights to those lessees. You take away and then you say, okay, even then it was not like this. So the whole case was fought on no evidence, no record, nothing. It was only that I think Puran was slightly educated or maybe he was financially well off, that he took the initiative of finding. And you know, when you have no land records, nothing to show on your compensation, neither you applied for under the then CPC 1889, 1888, 98 CPC, either of the admissions or production of documents. So entirely the case is construed on Rule 3 of 1924. Discrimination has been nudged. This bungalow owner lost in November 94. So now he filed an appeal in the district judge. So again this exhibit D 30 comes up. This is talking of the history of Jabalpur. Again 1861, how people as Elkadaris were fixed with the term, how season to accession or cession took place in 1818 of these villages around Jabalpur. Here he goes on to say that Jabalpur was created entirely on wasteland or grassland. So these 6-7 villages, only their wasteland and grasslands were taken, and that's how Jabalpur came up. I just talked of the 1763 Charter Act. No season could have been taken in 1818 because war was considered and declared to be not to take place after that. So nothing is what the pleading and the advocates are talking, because I can understand 1924-25, how much did you have in your hand? So the cantonment officer or the judge is purely deciding this case without realizing that the Cantonment Act of 1864, which was the first Cantonment Act, clearly gave the rights of a sub-registrar to the then cantonment executive officer, or called cantonment magistrate. So here the government of my lord is trying to state that Jabalpur was made out of this land. So these lands you don't need to resume, neither do you need to acquire, because there was nobody who was occupying these lands. That is why they were called wastelands. But Britishers had a simple policy in their law that nothing could have been given to anybody. So friends, we have to understand, why is the court talking of 1910 rules, why is it talking of Cantonment Code 61, admission, so many things, everything has to be taken. Now it goes down to say that under the TP Act 1882, read section 106. It says a fool's paradise that one does not know or believe that lands within the cantonment limits are government. Now he is termed the plaintiff that he is living in a fool's paradise. But you know, there is a mindset since 1898, after the notifications of the, that all lands after these notifications of 1889 or 1880 or 1870, these were all now government lands within the cantonment. Guys, even then there were military boundary pillars, even then there were cantonment boundary pillars. So please, we have to be very important on all this. Now this man Puran Singh loses in this district court also. So now he filed the case in 1924 to the highest authority, that is the Financial Commissioner of the Central Province. So because those days there was no high courts. So now he goes there, and the Financial Commissioner again takes the toe line and the thin line of the lower court and the appellate court, and he dismisses with the cost of 50 rupees. So you have to understand, we will not be given relief. Why we will not be given relief? Because we people don't know how to lead our evidence. And if you don't know how to lead our evidence, we don't know how to lead or how to make our pleads. Pleading is very important. This is a win-win case. Everything the DC wrote, Mr. Kadwai in 1924 wrote everything, that lands till 1905 were not acquired in Jabalpur. But Jabalpur, I remember when we visited Jabalpur, there was a Vidhayak or somebody called Mr. Choksi. The kind of arrogance he had, I remember, he simply asked a question, why are you here? We don't need you. I'm surprised. Today, Mr. Indu Rakhya's son, they don't talk, they don't want to be a part of it. And Mr. Indu Rakhya used to talk to me for hours together. Please, friends, wake up. This is a wake-up call for everybody. The court cases which I am stating now are only on pleadings. And when you have no pleading, you have no evidence. You have no evidence because you have no issues. We don't make the right issues also. So please, wake up. We were all old grants. We can easily win through. Thank you.